Welcome to Justice Matters. I'm Denise George, Attorney General of the U.S. Virgin Islands. Justice Matters is a program aimed to inform, engage, and empower you with knowledge of Virgin Islands laws that affect our everyday lives and our community. We have insightful discussions with special guests on the laws and related topics so you can be empowered to make a difference in our community. Today's topic is about a very serious yet sometimes misunderstood topic: sexual harassment in the workplace. We will have joining us today Gabriel Knight, who is the Strategy and Organizational Development Officer of the Division of Personnel, a strategy and organizational development unit here in the Virgin Islands government. Sexual harassment is a violation of the federal and local civil rights laws. The Virgin Islands Civil Rights Act, which prohibits sexual harassment, states, the legislature declares as the public policy of the government of the Virgin Islands that sexual harassment in employment is a type of sexual discrimination and as such constitutes an illegal and undesirable practice that goes against the established constitutional principle that the dignity of a human being is inviolable. Sexual harassment means any unwelcome sexual advances or requests for sexual favors or any other verbal or physical conduct of a sexual nature when A, submission to that conduct or those advances or requests is made either explicitly or implicitly as a term or condition of an individual's employment, or B, submission to or rejection of the conduct or advances or requests by an individual is used as a basis for employment decisions affecting the individual, or C, the conduct or advances or requests have the purpose or effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive working environment. The sanctions or penalties associated under the law for sexual harassment, the law says any person responsible for sexual harassment in employment as defined in this section shall incur civil liability, and that's civil liability as opposed to criminal liability, for a sum equal to double the amount of the damages that the action has caused the employee or job applicant, or for a sum of not less than $5,000 at the discretion of the court in those cases where pecuniary damages cannot be determined. So let's talk more about sexual harassment with Gabriel Knight. Gabriel Knight, who I said is the Strategy and Organizational Development Officer at the Division of Personnel, and he's involved in the training as well as investigations of sexual harassment. Well, welcome to Justice Matters, Mr. Knight.
Thank you for having me, A.G. George.
Okay, great. Now tell us, what is the definition, a simple definition, straightforward, of sexual harassment?
Sexual harassment always starts with unwelcome behavior. It's any type of conduct that is unwelcome, whether it's a sexual gesture, sexual nature, any type of physical or verbal gesture anything that's sexually oriented that's unwelcomed. And it's also followed by the condition that that person's submission to that behavior is either implicitly or explicitly part of a condition of their employment. And this is normally done in one of two ways. You can do it, which is what's called quid pro quo, or a hostile work environment.
So what's quid pro quo?
That is when you're giving something for something else, is the meaning of the phrase. And when it comes to sexual harassment, it means that that person saying yes or no to those sexual advances is used as a determining factor in their employment decisions, or the employment decisions about that person. So if you say yes to their sexual advances, you can get a promotion or get something tangible or intangible. Or if you say no, then something is taken away or you're treated differently.
Okay, now compare that to the hostile work environment.
So hostile work environment is when that conduct has the impact of unreasonably interfering with that person's work. And it goes to the point where it creates an environment where that person doesn't feel comfortable anymore going into work, and they feel very intimidated. And then you're creating a hostile work environment. And that's usually what's called severe and pervasive. And it could be a single incident that really has an impact on the person, or it can be something that's repeated. And when it becomes repeated, then you're talking about a consistent pattern of behavior that actually has that impact on that person, because now it's happening several times back to back, and that person is feeling very uncomfortable in the work environment.
Okay, for example, give me an example of the hostile work environment situation.
Hostile work environment would be someone repeatedly asking someone out. Let's keep it straightforward. They come in, they keep asking that person out, and they're making comments about how they would be great together as a couple or something of that sort. And that person is also telling them no, because remember, you're going back to being unwelcome. But it continues to go to the point now that person is associating that feeling of being asked out by someone they don't want to be asked out to with coming to work. And then now it follows into interrupting their work, because now you feel distracted. Because now you're thinking, if I go to this place or the lunchroom and this person's there, they're going to ask me out, I'm going to be uncomfortable. And now I'm in an environment that I'm not happy in, and it's affecting my work.
Okay, well, and then quid pro quo, well, that's pretty much self-explanatory. Something for something else.
Yes. It's self-explanatory. And it's the same thing where someone can say, you know what, if you go out with me, I will make sure that your name is first on a list of candidates, or I will give you preferential treatment on the schedule if you decide to do this for me, or if I have advance notice of something that's coming up, I'll make sure you're the first to know. And it goes the other way, where if they say no, then that person is treated differently from the other employees, because we're also looking at the fact that it's not just that person, but it's also how they're treated differently from other persons. So it's something that's taken away, and they're treated differently from the other employees. They're required to maybe extra assignments that other persons are required to, or something is taken away that normally they would give to other employees as well. So it's that exchange of something for something, or taking away something for not giving something else.
Now, does it always have to have the dynamic of a supervisor or someone in a position of authority, or can it be a dynamic of coworkers who are on the same level?
Absolutely.
With either quid pro quo or the hostile work environment. How would you do that?
Well,
not
both.
Really
Quid pro quo it's a little harder to do when you're coworkers.
Right.
When you're coworkers, your colleagues on the same level, because they don't have that ability to impact that person's growth.
They're not in a position of power.
Yeah, they're not in that position of power.
Right.
And it's very interesting, because it does take me back to something within the act, that actually the Virgin Islands Civil Rights Act, because when they define a supervisor, it doesn't necessarily need to be that person who is that direct supervisor, but is someone who is either directly involved in a decision about that employee, or they may be asked to weigh in on it. So when you're talking about maybe like a 360 peer review, you may get into quid pro quo for that as well. But for the most part, it's usually going to be your supervisor employee for quid pro quo. Now, for your hostile work environment and for the other factors, it can be colleagues. It can also be someone who is coming into the organization, or it could be a vendor that you deal with that is harassing an employee that comes in. There really isn't a limit on it. It could be opposite sex, male against female, or it can be a female harassing a male, or it could be one male harassing another, or two females as well. There really isn't a barrier in terms of who can harass who.
Okay, and you talked about, of course, the Virgin Islands Civil Rights Act for sexual harassment in the workplace. How does it define that?
For sexual harassment in the workplace, it goes back to the original definition. It's unwelcomed behavior that involves a sexual nature, requests for favors, things of that sort. And then it goes back into the same definition, where you are saying, if you do this for me in this particular sexual nature,
right.
I will give you something, or you have to actually do what I am saying that you need to do. Or it goes back to simply that behavior that's unwelcome is continued. And one of the key things that is mentioned in the EEO law, as well as the Virgin Islands Civil Rights Act, is that it's implicit or explicit. So it could be something, whether it's blatant and it's said, or it's something that's implied. And we always look at intent versus impact. Because somebody may say, well, that wasn't my intent, but then you look at the impact that it had on that person. That's something else we take into consideration as well. So it still follows the same logic when it comes to sexual harassment.
But what kind of balance is it that you're talking about, though? Because when you talk about, you compare the impact with the intent. When it comes to sexual harassment, the person who is being harassed, sometimes the person who's doing the harassing, so to speak, is like, oh, I didn't mean that. That was just a joke. How do you really make that balance? As I know, with your position, you're involved in the investigation of those cases. But generally speaking,
we start with what's called the reasonable person clause. And that is, how would a reasonable person interpret this under normal circumstances? And under normal circumstances, I mean someone else other than the person who's complaining. So how would a reasonable person interpret this behavior? So that's what we always start with. We look at that. And then from there, we go out into saying, okay, let's look at the context of the situation. Let's look at the context of it, look at what's surrounding it. Because it could be a situation in which someone is saying, we're going out together Friday night as a group. Would you like to join us? And somebody may interpret that as sexual harassment, or it's someone calling up someone repeatedly saying, please go out with me, please go out with me. And you're saying no, because then we're into that balance of it being unwelcomed, and then also how it's interpreted for someone who's a reasonable person. So we look at that. And then of course, you're looking at that repeated pattern, because you want to make sure that it's a repeated pattern, because there's behavior that is inappropriate. And there are a lot of things that are inappropriate when you get into like the things that you tell someone or comments you make about someone, and you go into whether it's comments about their body, the way they look, or any things of that sort. And then it goes into how often are you doing it? Is it all the time? Is it unwelcome? So a lot of those things play a role in the factors that we look at. And then, of course, we always look at what evidence that we collect. Because you may have the complainant that says one thing, and then the accused person says, well, no, that wasn't me. And that's why we also talk to all of the persons who are involved as witnesses, especially persons who may have spoken to them afterwards, because then they will tell us about the demeanor of that person outside of that context.
Of course, you mentioned, along with the Virgin Islands Civil Rights Act, you talk about what you said, the EEO. Just say for the audience, the listening audience.
Equal Employment Opportunity Commission. And that is on your federal level, who handles cases, and that would be anything outside of the Virgin Islands government. That would be anything in the private sector, where someone who has a complaint, they file a complaint, they would file that with the EEO Commission, and they would go through the guidelines of accepting the complaint, conducting their investigation, as well as presenting their findings. And based on, once their findings are done, whether it's substantiated or not, then that person who files a complaint can actually take it a step further. Sexual harassment is illegal. It is a violation of civil rights, Title VII for the Civil Rights Act, and it actually violates their civil rights. And based on how far the investigation goes, it can actually get to the point where it goes into your criminal law, and then you're prosecuted on a criminal level, depending on the type of harassment that's occurred.
Yes, and I did want to mention that, and because that's a question that I get often. And it said, well, what's the difference between sexual assault and sexual harassment? And so sometimes, and I'm going to let you answer it too, but sometimes I just say that, well, it can be both at the same time, because sexual assault in a workplace can also be sexual harassment. And then sexual harassment may or may not include a sexual assault as far as a criminal act. So it just depends on exactly what the facts are. So did I do that right?
That is correct. The way I look at it is, and the way we interpret it is, that you can start with sexual harassment, and it can include sexual assault, because it depends on what the harassment is. And that's when you go into your physical harassment. And that involves any type of touching for pretty much anytime you touch somebody and it's unwelcome,
right?
And then it goes into a different phrase.
Exactly, and then should we go into those crimes such as unlawful sexual contact?
Yes.
Rape. So what are the civil penalties?
Your penalties, it's up to double whatever the damages are. That are claimed by the person who files the complaint, or it can go beyond that. It's really at the discretion of the court or the judge, and financially, or it can be not less than $5,000. So you can actually face that option as well as any corrective measures that will happen to that person. And that goes up to and including termination. And the termination portion in terms of that person also depends on the severity of the act. So
is there then an administrative process sometimes?
There is an administrative process. And it starts when someone comes into work. As a new employer, as a new employee, one of the requirements is that everyone should have some type of sexual orientation training. And that's the start of the process. And I'm going back to more of the basics because the goal of everything involving sexual harassment is more of a preventative measure. It's designed to prevent the actual act happening. And of course, you merge into consequences. Then you go into progressive discipline. And then it's whether it involves counseling, in-house counseling, a written reprimand, a suspension, a termination. And a lot of that also depends on whether this is something that is repeated even after the counseling. And then you can order some things where the termination is immediate. But progressive discipline is part of that process as it's involved. So once that actually happens, now before you get to that point, once the complaint is made, that employee is always encouraged to tell their direct supervisor that I feel like I've been sexually harassed. And the first step is always the direct supervisor. Unless that supervisor is a person that harassed them, then you would go to the next person up, the human resources manager, or even the head of the agency. What
is that process then? So you go straight first to the immediate supervisor, or you go above that supervisor. Well, right? So what is it that the employer has to do?
The employer's job, among the many things that they do, is to make sure that that employee has a working environment that is free of sexual harassment. And part of that involves having a sexual harassment policy in place, making sure it's accessible to everyone who starts as an employee, and making sure there's periodic training. And for anybody who's looking for it, they understand here's the material on it, and here's our stance, because you need to feel safe going into that environment. And here's our stance on what sexual harassment is. Here's how we feel about it. And here's what you should do. So you're providing clear steps to that employee if you feel like you've been harassed, and not just if they've been harassed, but also if they've witnessed it. If you're a witness of someone else being harassed, where do I go? And from there, the first person will be your immediate supervisor. And if that immediate supervisor is involved, it would go to the human resources or the agency head, and you take that information to them. Now, from that point, the agency has a responsibility to investigate. They're liable if it's something that they knew about and that they did nothing. If you were aware of it as an employer, then you're very liable for it, because then as the employer, you become liable financially as well, because then you can also be fined for being aware of it and not doing anything. And that's a lot of times where you will see them in the news, where agencies or companies, big companies, are charged hefty fines. And those are punitive damages because they found that they were aware of it, they allowed it to continue, and they did nothing. And then here's the impact you had on the employees.
And sometimes there's retaliation. What is retaliation all about?
Retaliation is very unfortunate, and it goes right into confidentiality. And one of the things two things we always we caution everyone is no retaliation, and also maintain confidentiality. When we investigate these cases, we make sure that only the persons who need to know are involved. And in this case, it would be the witnesses, the person who complained, the person who is accused of it, as well as the agency head, because they have a right to know what's happening. So from there, we want to make sure confidentiality is maintained to the highest degree as possible. There are some things that will have to be mentioned to other persons as part of the investigation, but not unnecessarily. So confidentiality is there. Now, retaliation is any act that anyone takes against someone who has either filed a complaint or even someone who is accused. because the person who filed a complaint has the right not to be retaliated against. And it could be any action that's taken against that person. Anything that involves treating them differently, whether it's from a supervisor or a coworker, and they have been treated in a different way. And there isn't anything specific. Once the claim comes out, then of course that's something that is investigated.
Okay, and real quickly with respect to how they're treated. Immediately, sometimes there is a concern when you have two persons working in the same environment, even if it's the direct supervisor. Then what do you do with respect to separating them?
It's not so much a difficult challenge, but it escalates into how severe the harassment is, because you will run into situations where after having one or two interviews, you have found that there is evidence to substantiate that there's probable cause. And then at that point, you do need to make sure that those two persons are separated. Now, for the employee who brought the complaint, that person wouldn't be asked to move. It would be the person who was actually accused of the harassment. And that would be our first step with it, because what we're looking at is that you have someone who is uncomfortable. And it takes a lot to actually step forward for sexual harassment.
Sexual harassment through digital communication. What does that mean?
That is your sexual harassment on any digital format. And it's the same as in person, because you're still doing the same thing. And when we look at it, even though someone may say, well, it's online, it's not the same, when we go back to what's happening, it goes back to one, it's unwelcomed.
Right.
It's unwelcomed. And then it's actually made even worse if you two work in the same company, because now what you've done offline, even if it's outside of work hours, it's having an impact on the work environment. And now that person is uncomfortable because of what they did on Facebook or Instagram in terms of exposing whatever they wanted to expose or whatever they told them. Now you're back in the same environment with this person. So even though it happened outside of work and it happened digitally, it's still coming back into the office and it's still having an impact on that person. For the government of the Virgin Islands, the Division of Personnel was assigned the responsibility of investigating sexual harassment cases. That's part of the Virgin Islands Code and the act I referenced earlier. So, and it was the Division of Personnel, and it is headed by the Director for the Division of Personnel. An employee can go within their agency and they can take it to the agency, and they take it to the agency head and they'll take it to the Director for the Division of Personnel. But if for some reason that employee does not feel comfortable at all, or for some reason, whatever the situation is, they don't feel comfortable within the agency, they can go directly to the Director.
But they do have a choice.
Yes, because the agency is required to address it. Now, that person still may say, I'm going to take it to the Division of Personnel. And we can't control that, because they do have a right to go to the Director for the Division of Personnel, or even take it to their agency and say, okay, you've done this, here's your findings, but here's the next step that I want to go to. Because initially, the goal is always to try to stop it from getting to the level of a violation of sexual harassment. You want to make sure that it's something that you stop before it begins. And that's usually, so if it's conduct that is inappropriate and something that you overhear, you supervisors or even agency heads, and for them being proactive by making sure, hey, these are the things that are inappropriate, please don't do these at work, and making sure that if something does happen, that you address it, and you want to address it right away, immediately, because in order for it to get to the point where it violates that civil right, you are going back to where it's something that's severe and pervasive.
So what do you say to a person if you have a complaint, you feel that you are being sexually harassed at work? Who do you contact?
First person you contact is your direct supervisor. You want to let your direct supervisor know what's happening. And in most cases, they will reach out to their direct supervisor first. And within government, we always have to take into consideration whether that person is unionized as well. Because if they are part of a union, then their union is going to become part of that as well. So they're also aware of it. But ideally, letting the agency know, because you do want to make sure that if it's something that's happened the first time, that agency has the opportunity to say, we've corrected it. Because if it's just once and it hasn't gotten to that repeated pattern or it's pervasive, give that agency a chance to make that correction.
And if the situation is that the person who they believe is harassing them is the head of that agency, where does that person go?
The director of the Division of
The
Personnel.
Division of Personnel. Okay, let's talk quickly about prevention.
Yes.
What can we do, or what is it that the Division of Personnel, or you do, as far as your work with respect to preventing sexual harassment in the workplace, and even something that even private, in the private industry, can use, private employers, with respect to preventing that from happening?
For private employers, what private employers should do is adopt a policy. Develop a sexual harassment policy and make sure that everyone has a copy of it. And make sure that as everyone comes in as a new employee, they are made aware of it. Here is our policy, here's a copy of it. And for some reason, God forbid you lose it, please reach out to me and get another copy so you can reference it, but always make sure that it's accessible. More importantly, supervisors. Always make sure supervisors get a refresher training on sexual harassment prevention in terms of your do's and don'ts, the things that you need to be aware of as you're going through your everyday behavior, or the things that you may do. Make sure there's always those reminders that are there. And the GVI does that. We do have our new employee welcome orientation. So for any employee as a new hire or as a new transfer, that's a requirement. They do go through that process. So even if you've been in government for 6 or 7 years, you move from one agency to another, you're in the orientation, because then that's part of the refresher training as well. And then, of course, we do conduct trainings by request for agencies that says, I'd like to do a training for my agency. They can request us and we would do that as well. And that's part of our Respect at Work series, because our goal is respecting everyone's rights in the workplace, and sexual harassment prevention is actually one of them that we do. So we do have, the GVI does have a sexual harassment policy. It is available on the Division of Personnel's website, so it's accessible to everyone there. Even if someone files a complaint for sexual harassment and it's not substantiated, that person is not penalized for that, because they do have a right to file a complaint as long as it's in good faith. Good faith
and not malicious.
Yes. If they do file a complaint, and of course during the investigation we found that it's false, then there's corrective action that's taken. And yes.
And sometimes it's not so much false, but if you don't find sufficient evidence to substantiate it,
well, if someone did it in good faith, no action will be taken against that person. But they did it in bad faith, then that's when your corrective action up to and including termination can actually happen. But with that said, I think the one thing that I would tell everyone is pay attention to sexual harassment in terms of the things that we say as well as what we do, and make sure that the actions that we've taken are welcomed, or make sure they're not unwelcomed, because the biggest factor that I find is always that difference between intent and impact. A lot of times people will do things because maybe it could be a cultural difference, or they simply say, well, I didn't think it was a big deal. But they have to take themselves out of that other person's shoes and be able to be cognizant of what that person may be comfortable with. And especially when you are talking about little things, like sometimes people will call somebody in a particular way. Sometimes they may not say their name, and they may seep that person to get their attention. And it depends on the context. And always to remember that you're at work. Especially when you're at work, a lot of those things come into play, and you have to be very aware of the surroundings and the things that you're doing that could actually be construed in one way or another, and it could be offensive. And it's especially even more important for persons who are supervisors.
Thank you so much for that, because I think that that's really wise information that you're giving here. So thank you so much for joining us on Justice Matters.
Thank you very much for having me, AG George.
And I certainly hope that cleared up a lot of questions that you may have had with respect to sexual harassment. I want to thank all of you for joining us on this episode of Justice Matters.